One last question on this point. As you've indicated, the Young Offenders Act gives a very wide opportunity to appeal, but when should you appeal?
Whenever you lose. I think...
We'd be seeing you too much.
I mean, I think that one of the problems under the Juvenile Delinquents Act was that the right of appeal was so limited. Essentially, you couldn't go to the Supreme Court and get special leave unless you were saying there was no evidence. In other words, that the judge really acted arbitrarily. The rights of appeal against conviction are so much wider now that I think that there'll be an increase in the number of appeals, and I think that properly so, if we're going to start treating juveniles or children more like adults, and they should have appeal rights more like adults. I think one of the interesting questions is when will sentence appeals or disposition appeals be brought, and maybe that's something we can talk about more when you talk about review, John, but the Court of Appeal, when it deals with adult sentence appeals, really takes a fairly liberal view. If they don't consider the sentence fit, then they will deal with it. They will vary it. They're not concerned in Ontario very much with their errors in principle anymore. I don't know whether they will take the same view with respect to appeals from dispositions. I expect they will show a certain deference to the juvenile court judges who are now youth court judges who have been dealing with these children for quite a number of years and are used to the facilities. It may be that they will show more deference to the youth court than they would to other provincial courts where they have more experience in dealing with adults and adult dispositions.
I respectfully suggest that if there is a flood of dispositional appeals to the Court of Appeal, that some of the liberal manner in which the Court of Appeal has approached the matter of sentence might change, and errors in principle will become much more important, especially when you do have a right to bring a review where presumably you're going to be dealing with things like fitness and change of circumstance. So I'd suggest that if you're going to go to the Court of Appeal, it would be nice if you had an error in principle that you could show them and show them why the sentence was not right when it was imposed, not that it's not right now because other things have happened. That's what the review procedures are there for. Marc, let me just ask you one more question on appeals before we leave the topic. Do you think that the presence of young offenders in the Court of Appeal is going to have an effect on sentencing tariffs in general?
Well, I mean, I think this is one thing that we have to be concerned about. Up till now, really the youngest people that the Court of Appeal deals with are the 16 and the 17-year-olds, and they really treat them like babies. In the sense that a 16-year-old has to do something pretty horrendous before the Court of Appeal will consider sending them to jail, let alone sending them to any place like the penitentiary. Once these new now that the new provisions are in, once these new appeals come in and the Court of Appeal gets used to dealing with 14-year-olds and 15-year-olds who they're sending to jail or asking to consider whether they should be sent to jail, the 16 and 17-year-olds are going to look pretty old. And particularly once they start treating a young offender record like they would an ordinary criminal record, which they may very well start to do, then I don't think the 16-year-olds who commit the 5 break-and-enters are going to get off so lightly in the Court of Appeal as they used to when they were the youngest ones really in the court.
Thanks, Marc. If we could move on to reviews then, because the time is short. The JDA contained a much maligned section which allowed for recall before the court with a juvenile who'd been finally sentenced for delinquency but was into further trouble. And as you probably know, as a result of the enactment of the charter, that section was read down so that no more onerous punishment could have been imposed under the JDA than was originally imposed. Well, the YOA doesn't really have anything in it like that, but it does contain very elaborate provisions for post-dispositional reviews. And perhaps not surprisingly, with the exception of one case, the disposition can only be adjusted downward on a review. Now, the best way to understand the review provisions is to sit down with the YOA and read them over and over and over. But if I can briefly summarize them, in effect, they amount to a judicial parole system. There's two basic categories of reviews. There's reviews of custodial dispositions and reviews of non-custodial dispositions. With respect to reviews of custodial dispositions exceeding 1 year, the YOA calls for a mandatory review at the end of 1 year from the date of the most recent disposition. Where there are dispositions exceeding 1 year for more than one offense, the automatic review occurs 1 year from the date of the earliest disposition. Now, a custodial review may take place at an earlier time at the request of an interested party. That request for a review can come no earlier than 6 months from the date of the most recent disposition, unless the leave of a youth court judge is obtained for an earlier review. The criteria for a custodial review are found in section 28.4, and they are: 1, that the young person has made sufficient progress to justify a change; 2, that there's been a material change in circumstance; 3, that there are new services available. And I suggest a very interesting question will be whether that means that the service has to be one that didn't exist at the time of the disposition, or whether it means that the service was not available to the particular offender at the time of the disposition. Anyways, and 4, a rather general category: any other appropriate grounds for review. So on a review, the court, and in my opinion, the reviewing court is the court which imposed the original disposition. And that may well be a factor to consider in deciding whether or not you want to review, because I think you have to go back before the same judge who imposed the disposition and convince him he was wrong, or things have sufficiently changed that he should give a different disposition. On a review, the court's to consider a progress report and the submissions of all of the interested parties. Now, Section 29 contains a provision which allows a variation in a disposition without a full review. The provincial director can recommend that a young person in custody be released and placed on probation. Notice of that recommendation is then sent to the interested parties, which includes in the notice the reasons of the provincial director for saying why release is appropriate. After receiving the notice, the interested parties have 10 days to decide whether they want a review. If they don't apply for a review, the youth court may then release the young person on probation. The youth court doesn't have to release, and if the youth court, he or she, doesn't release, then the provincial director can bring a review. There is provisions for a non-custodial review. Basically, the time limits are the same. Basically, the same requirement of a material change of circumstance or an inability to satisfy the disposition, the non-custodial disposition, applies. You can read those sections at your leisure. The third type of review is a review that arises upon a failure to comply with a disposition, and that's the only type of review which can result in a more onerous imposition or a more onerous disposition. And it's quite clear that on a review under Section 33, which is the failure to comply review, the failure to comply has to be proven beyond a reasonable doubt, which would suggest that basically you're going to have the same type of trial that you would have on a fail to comply charge in the adult system. But the mechanics of that particular procedure are not very well set out, in my opinion, in the Act. If the authorities, and it's interesting, I think, that for some reason the federal government seems to think that attorney generals and their agents go around laying informations, because that's the way in which you start a Section 33 review. But if the authorities decide to proceed under Section 33, then they are stopped from proceeding under the criminal code. So it's quite a significant decision, whoever is going to make it, as to which way you should proceed. There are no appeals from reviews, which is another factor that has to be borne in mind when you decide to go the review route. Presumably that's because all reviews should be beneficial to the young offender. Putting aside totally the question of whether that does justice to the Crown, can I ask you, Jeff, do you think that there would be situations where you should have a right to appeal from a review? And since you don't, do you think that a prerogative remedy would lie to challenge a review decision?
Well, I would think that a prerogative remedy would lie, because it is a decision that's clearly affecting the rights of an individual, and I don't see any right of appeal, as you point out. So I think the only possible remedy would be through a prerogative remedy, and the difficulties that you have there. You wouldn't have the difficulty of the usual problem that you can't bring your prerogative remedy because there are appeal rights, but you have the other problems of excess of jurisdiction and something pretty clear on the record, or a gross error of law, in order to sustain that form of an appeal. I was wondering, just before you leave this area, if you might just, you left out section 30 on review boards, and whether I have a passion to find out the Ontario response, whether you know whether Ontario will be setting up review boards and to act in lieu of judges for the purpose of these review hearings.
Well, I am, of course, not speaking on behalf of the province of Ontario, but I do understand that the review board procedures in Section 30 are not going to be implemented in the province of Ontario at the present time. The reasons for that are probably many, but since it's not going to be a factor, there's not really much point in me going into them. We are supposed to leave some time for questions, and we've already had one question, and I'll ask Marc, perhaps, if he'd hazard a guess as to the answer of the question. The question is that a finding of delinquency was made under the Juvenile Delinquents Act before April 2nd, 1984. The disposition is to take place in June of 1984. The judge says he can make the disposition under the JDA. Can he? Marc?
I would have thought that he can't if it's a matter that would be a criminal code matter if dealt with, in other words, if the underlying offense, the delinquency, is a criminal code matter by reason of Section 79 2B. Which I think the effect of it is that where the adjudication of delinquency is made prior to the proclamation of this act, then after that the disposition is to be made pursuant to the Young Offenders Act. Now, I think there's a different result if it's something like truancy or something, I'm not sure, but because of Section 79 sub 3 would seem to indicate that that it's very much up in the air as the whole problem of provincial offenses, but it would seem that perhaps he can continue under the Juvenile Delinquents Act by reason of 79 sub 3, but it would make an interesting appeal, shall we say.
And I'd suggest to whoever asked the question that you better come up with some authority if you're going to try to convince him that he can't do it, because I would think that the weight of authority, or the weight of the statute, probably suggests that he can. We've got maybe 2 minutes. Jeff, sorry, did you want to add something?
You might be able to argue, if you see the Young Offenders Act as a more penal in terms of the opportunities that you could refer to. Arguably, Section 11 I of the Charter of Rights, and the fact that the punishment for the offense has been varied between the time of the commission and the time of sentencing, that the accused would be entitled to the benefit of the lesser punishment, which arguably might be available to you under the Juvenile Delinquents Act, since it was such a benign, loving act compared to the Young Offenders Act.
So that's an interesting argument, Jeff. We do have We have 2 minutes. Are there any questions that you'd like to ask either Marc or Jeff? Yes, back there.
I have a question based on conditions for secure custody. This relates to judicial release and anything else. My understanding is there are some measures on judicial release, or instead of judicial release, will, on pleadings of guilt, adjourn the matter and send the young offender to still acts, which is kind of peaceful lesson, and then determine that secure custody is no longer advisable. I'm wondering what kind of argument would be served against that, keeping in mind Section 143, especially if the young offender is
Especially if he's under 14 years of age.
Well, I think that if you look at it this way, the Act says that the court can only put a disposition that is of the nature of treatment disposition. If it has the consent of the parents, it can dispense with the consent of the parents if they're not actively involved, but it needs the consent of the child. So then if the purpose for going to SILAPS is not treatment, and then it's simply, and it is, if it's not treatment, then it is security, custodial care, then I would argue that if it is then custodial care, that it has to comply with the sections, and that is in effect a disposition, even if it's for 2 weeks. So it must comply with the sections for dispositions that are of a custody nature. And if it can't comply with that, then the court has no authority to do that. And it can't say that it's of a condition nature, the last section of Section 20, or that it's for the purpose of treatment, particularly if the child's not consenting.
Well, our time's up, and thanks very much for your attention.
Thank you very much, Bill. Okay, we now move on to rights of counsel. Mr. Holden, Mr. McGuigan, Mr. McGee. Thanks, guys. Good stuff. Introduce Mr. Holden, who will chair the last, but certainly not the least, session of the program, that of the right to counsel. Mr. Holden is a graduate of the University of Western Ontario. Osgoode Hall in 1969, called to the bar in 1971. He was a prosecutor with the Department of Justice from 1971 to 72, and in 72 to 83 was in private practice. He is a member of the executive of the Criminal Lawyers Association from 1979 to 1983, and is now the Deputy Director of the Legal Aid Plan for Ontario. Bob, the chair is yours.
Thank you, Your Honor. It's my pleasure to introduce our two experts, Mr. McGee and Mr. McGuigan. I must say it's my pleasure because clearly we're dealing here with two of the, in my view at least, giants of the criminal bar in this province. If I could introduce Mr. McGee. He was born in Toronto, attended school here, graduated from the University of Toronto and Osgoode Hall. He was called to the bar in 1966. He was in private practice for a short period of time and then joined the Crown Attorney's Office in York in 1967. In 1977, he was appointed Deputy Crown Attorney and was in charge of all criminal prosecutions in the downtown office. I think it would be fair to say, however, that certainly anybody who practiced criminal law in Toronto recognized Bob McGee as in fact being the chief crown of this jurisdiction. In 1983, he resigned from the Crown's office and entered private practice. Has established a very good practice and is associated with the firm of Humphrey, Ecclestone, and Durno. Leo McGuigan was called to the bar in 1960, having graduated from Osgoode Hall. He was in private practice for approximately a decade. He joined the Crown Attorney's staff in 1970. In 1975, he was appointed Crown Attorney for the Judicial District of Peel. In 1978, he was appointed Regional Crown Attorney for the Central Division of Ontario. I think what we'll do to start, this really isn't part of the agenda that was handed out, but I think it might be useful if we began at Section 11, which we'll be dealing with primarily. turn to that section, I can advise you as to how the Ontario Legal Aid Plan is responding to the requirements of this section. You look at 11 sub 4. It says, where a young person at his trial or a hearing or review wishes to obtain counsel but is unable to do so, the youth court before which the hearing, trial, or review is held, or the review board before which the review is held, A, shall, where there is a legal aid or assistance program available in the province, refer the young person to that program for the appointment of counsel. Now, we have advised the area directors throughout the province that if somebody is referred by a judge under 11.4a, they should deal with the application as they would in any other case. They may grant a certificate. On the other hand, they may refuse to grant a certificate either because of the nature of the offense or because of the financial circumstances of the young person or the young person's family. So if in fact a refusal occurs at that stage, we go to 11.4b, where no legal aid or assistance program is available, or the young person is unable to obtain counsel through such a program. The judge may, and on the request of the young person shall, direct that the young person be represented by counsel. So that's a direction, and that takes us to sub 5, where a direction is made under paragraph 4b in respect of a young person. The Attorney General of the province in which the direction is made shall appoint counsel or cause counsel to be appointed to represent the young person. You can see that has very extensive ramifications when the Attorney General is in fact appointing defense counsel. Now, what we have done, we've worked out an arrangement which for the first 6 months, we have agreed that when the Attorney General is required to appoint counsel, the young person will be sent back to the area office and a legal aid certificate will be granted, in spite of the fact that a certificate was denied originally. We're keeping very careful statistics to see what the cost is. It's been estimated that for the year beginning 1985, April 1st, 1985, that this act could increase the costs to the legal aid plan in excess of $10 million. So we're very carefully watching it, but we want to ensure that when the judge wishes counsel appointed, that in fact we will be there to grant a certificate. Now, my first question to Mr. McGee and Mr. McGuigan is, how do you think these appointment provisions of Section 11 will affect could affect the defense bar? Bob?
Well, if the system you set out, Bob, works, I would think it will probably continue, but it would seem to me that $10 million is a pretty revolutionary and high figure, bearing in mind the complaints already about legal aid bills. And I would think reading that subsection 5, where a direction is made under paragraph 4b in respect of a young person, the Attorney General shall appoint counsel, assuming that your figures are right, and it's going to cost $10 million if the person comes back to your system and you have to give them a legal aid certificate, that the prohibitive cost of that program would necessarily lead to the consideration by the AG, I would think, of the public defender system, which is something that I think he's kicked around for some years now, and there have been a number of studies into it. But the wording of that section puts it right on the line, because the Attorney General, assuming the youth can't get counsel any other way, has to, he has no discretion, has to assign counsel to him. And we're dealing here with, as of April of next year, with a huge number of people. we're looking at an increase in our youthful offenders courts of something like 25% of the present criminal business that's going on in our provincial, county, and Supreme Courts. So you're transferring 25% of that business to juvenile court, or to youthful court or youth court, and you're saying to the Attorney General that in certain circumstances, and I would submit that it'd be a large number, you shall sign counsel. And I don't think there's going to be any way out of it. If it's $10 million, they can do it a lot cheaper under a public defender system, and I think that's what you're looking at. That'd be my opinion, anyway.
Leo?
Well, based on the raises that we as Crown attorneys have received recently, there's obviously a shortage of money. So that the fact that this 10 million figure has been mentioned indicates to me that consideration would have to be given to the idea of a public defender. Now, this may surprise you, but I personally wouldn't be in favor of that, but probably not for the reasons, or at least for one of the reasons that have been advanced, and that is that the public defender, because he is being employed and paid by the Attorney General, and the Crown Attorney is being employed and paid by the Attorney General, would not be independent in carrying out his duties on behalf of the young offender. But the fact of the matter is that at some point, the question of finances, and that's particularly important in these days when there doesn't seem to be enough money available for this type of expenditure. It seems to me it's something that the Attorney General at some stage is going to have to consider.
Thank you, Leo. Many of the provinces have hired a number of full-time lawyers to provide what is really a duty counsel service on a 24-hour basis. We're trying to avoid that cost if we can. To that end, the following arrangement has been made. The Law Society is utilizing the lawyer referral service to try to assist the young offenders who have been arrested, or alleged young offenders. And some people may not be aware of that. The situation is this: anybody who is on the lawyer referral service criminal panel was sent a letter in March, was advised about the upcoming implementation of the Young Offenders Act, and was asked if they would be prepared to provide their home number so that they could be reached on a 24-hour basis. And those who responded to that request have been put on a list, and these lists are present in every police station in Ontario. Now, if you're not on the list and you want to be on the list, and I suggest that everybody should be on this list who's interested in doing a lot of criminal work, they should call the Lawyer Referral Service at the Law Society and ask to speak to John Beaufoy, who is updating the lists on a regular basis.
I don't know whether I'm on that list, but I got a call the other morning about 7 a.m. Monday from a police officer at a station in North Toronto who indicated that he had a young offender there who was deaf-mute and wanted me to come up. It was a rather serious offense, apparently, that he was charged with, presumably to be there while the statement was taken, as is required under this act. I wasn't able to go, and I phoned Dan Kirby, who's here in the audience, also an ex-Crown attorney who's in private practice, and Dan went up. But the thought suddenly occurred to me later, and I guess this deals with the right of counsel under Section 56. Supposing a statement had been taken and Dan was there, he would presumably be a witness. The youthful offender would be required, or could be asked whether he wished him to be there, and I would assume in these circumstances he would be there. He would then become a witness, and what would that do to his position as counsel for this young man when he came up to court? I know it's happened in Toronto a couple of times, and counsel in that position are normally subpoenaed and brought to court. I know Leo's got a rather funny incident that occurred in his bailiwick of a similar situation, and I just wondered if he could tell us about his experience with that kind of procedure, which has now been written right into this act. That is, you as counsel may be called at any hour of the day or night to sit in and witness a statement of your client. You become a witness, you can't act for him. That's the way I see it. Leo?
Well, I think that's correct. Mr. Justice Ewaschuk this morning referred to a case in which, in the Juvenile Delinquent Act statement, that the parent, the judge in that case didn't decide whether or not the parent was a person in authority. I think a pretty good argument that the parent in this instance was not a person in authority. But in any event, he did rule that the parent was a necessary witness. So it seems to me that even if, as Mr. Justice Ewaschuk says, that's probably incorrect, that decision, it has the weight of the Supreme Court of Ontario behind it. He may be free not to follow it, but at the present time, someone who is appearing in the Young Offenders Act court is going to be hard-pressed not to follow it. So it follows from that, it seems to me, on two bases. Number one, that counsel who appears at the taking of a statement, is present for the taking of the statement, may very well be a necessary witness in the sense that he is a person in authority. The second aspect of it is that the Crown, being aware of the fact that the lawyer is present, will in all likelihood subpoena the counsel as a witness for the purposes of a voir dire. We had the matter that Bob McGee's referring to is we had a fairly serious case. The matter is still before the courts on another aspect, so I won't go into the great details, but the lawyer arrived at the police station with his client in tow, and he asked to be present in the interview room while the statement was being taken. He was present in the room. The client supplied a statement to the police, which was recorded by them. And as they had completed the statement, the lawyer stood up and said to the police officer, "Well, that's a voluntary statement if I've ever seen one." That aspect was duly noted by the officer, as was his duty to do. And consequently, at the time of the trial, actually there was a preliminary, but at the time of the preliminary, which was followed by a plea, the question of voluntariness of the statement was an issue that was not too difficult to establish.
It happened a few years ago in Toronto here. Kenny Danson, I don't know whether Kenny's here today or not. I guess half the audience is gone anyway, but Kenny took his client to the station and he confessed to a murder. And Kenny sat there. He was pretty junior counsel at the time, and the homicide officer said, "Do you want to stay?" And he said, "Yes, I'd like to." And they said, "Well, you know what that means, don't you?" And he said, "Yes, I do," but I don't think he did. At the completion of an inculpatory statement, I think this kid had murdered his father by hitting him over the head with a baseball bat. The police officers asked Kenny if he'd sign the statement as a witness, and he did. And this was some years ago when we used to have to put cases through the grand jury, and the indictments had the names of all the witnesses typed on the back. And we showed up in the assignment court before Chief Justice Dalton C. Wells, and lo and behold, there was Ken still acting for this fellow, and lo and behold, there was his name on the back of the indictment as a witness. So the Chief Justice saw the name and made some comment to Ken that he should get opinion from the Law Society, which he did. The Law Society opinion was, and he was directed to appear in court, he could act for the accused on all aspects of the trial except the voir dire and the issue of the admissibility of the statement. He therefore had to retain other counsel, and I think he had retained Ian Scott. And Ian Scott and Ken were both acting for the accused, and when it came time for the voir dire, Ken had to step down and Scott took over. So I think it ended in a plea too, that case, but those are the kind of situations you can get yourself into, and this act here seems to guarantee that some of you out there are going to get into that kind of an area, so you better be careful.
These fellows could reminisce forever. Let's get
Yeah.
down to the points here. Leo, may I ask you this question, please? In your view, what is the scope under this act of the right to counsel?
Well, as Brian McIntyre indicated this morning, this act is kind of a welcome change to Crowns. And the reason for that is, as you all know, under the Juvenile Delinquents Act, it was kind of a treatment, social welfare, kind father, social work type atmosphere. And if someone acted as an adversary, that is the Crown, and in many instances applied also to defense counsel, the judges looked upon that as not in keeping with the spirit of the Juvenile Delinquent Act. And now with the new act, it's strictly an adversarial system, the same as in the adult court, probably with two exceptions that I can see. Before getting to those exceptions, the Crown, by virtue of Section 12 of the Crown Attorneys Act, is required to prosecute indictable offenses. So they have to prosecute indictable offenses. And, Your Honor, that may be a very big stick to require the Crowns, in fact, to be present in court in these prosecutions, because in the old days, police officers and students and sometimes anybody else we could find, we would send up to do the prosecutions, not because we didn't feel they were important, but because of the fact that it was very, very difficult to go into the ordinary court and act as an adversary and go into the other court and be a sort of a semi-social worker. And I never had training in social work, and I found it extremely difficult. And now, of course, that is not prevalent. And two areas, though, in which I would think it would be different, and one of those would be where the young person is unrepresented. And I feel that even in adult court, depending on the sophistication of the accused in the adult court, when the person is unrepresented, your requirements of, I suppose I was going to say requirements of fairness, but we're always fair. You have additional requirements of fairness and concern in relation to an accused in certain circumstances. And I would think that that would always prevail with an undefended young person. Now, another area that might possibly arise, and this would arise by virtue of Section 11(8) of the Young Offenders Act. Now, this is a situation in which it comes to the attention of the judge that it might be in the best interest of the young offender to be represented by his own counsel as opposed to the counsel that is hired by his parents, in that there is a conflict, a difference of opinion as to what methods should be followed, what procedures should be followed, what representation should be made. Now, the judge under that section has the right to take a look at the situation, investigate it, and decide whether or not it would be in the best interest that the young person have his own counsel. Now, I can see a difference in the obligation of the Crown that might arise on the rare occasion, and that is that information could come to the Crown that defense counsel is acting in the interests of the parent contrary to the interests of the young person. Now, that information could come to you in many ways. Probably the two ways you would hear it would be some of the court staff might indicate that to you, or the young offender might indicate it to the custodial officers if he happens to be in custody. I would feel that there would be an obligation on the Crown at that particular point to bring this to the attention of the judge, so that if he so desired, the provisions of Section 11.8 could come into play, and he could decide whether or not a counsel should be appointed for the young offender other than the one that's presently attending to his affairs.
Following up on that, Bob, do you see any problems which might arise as a result of the question of an adult retaining you and you then actually representing the young offender in court?
Well, I certainly can. I would think if Leo's staff started adopting the practice of revealing to the court that they've come into possession of information that the young offender may not be represented by independent counsel, and defense counsel out in Brampton start losing retainers because of Leo's staff's action. Leo, the defense bar out there, may even be angrier at you than they are now. I don't think there's any doubt as a matter of practice that at least the cases that I've done in the youth court in my limited stint as a defense counsel, there's no question about who retains you if you're acting for a young offender. It's the family. The parents retain you. They're the people that walk in and put the check down and ask you to defend their child. And there's no question that, practically speaking, it's difficult for counsel to adopt an independent role with respect to that child when the people that are paying the freight are the parents. And I don't think there's any doubt that this subsection 8 of section 11, which allows the judge, upon information received, it may be the way Leo suggests, it may be other ways, it may just be by his observation in court, allows the judge to investigate. In fact, requires him to investigate, as far as I can see, whether the young person has an independent counsel that is independent from the wishes of the parent. That kind of a subsection, I think, is going to lead to a whole lot of difficulty, because it's going to allow the judge to inquire into the circumstances of the retainer and surely to get into the issue of solicitor-client privilege. And I can see untold problems coming from that subsection, because there's no doubt that quite often the interests of the child are completely different than his wishes. The parents may have, and the term interest, I submit, I guess a fair inference could be drawn that means wishes. Supposing the child says, I don't wish to stay with my parents anymore, I want the judge to put me in a youth home or a group home or a custodial setting, or I want to go and live with my aunt down in Windsor. And the parents are saying to you, look, we retained you as counsel, we want him to stay at home. This is where his home is, we want him to stay here. We don't want him being shipped off anywhere else. Now, what do you do in a situation like that? It would seem to me under this act, the way it's drafted now, your obligation obviously is to the young offender. And whether his interests are opposed to what his wishes are and what the terms of that section mean, I submit are open to a lot of debate and are going to be very difficult problems in the future.
Leo, I know that you were present this morning when Mr. Justice Ewaschuk was discussing Section 56, and I know that you were somewhat concerned about some of the comments that were made then. Would you like to discuss that, please?
Well, actually, I was quite happy with the comments that were made, because when I was reviewing this last night, Section 56, which is the law concerning the admissibility of statements, gave me considerable concern as a Crown. And if you look at Section 56, it says, subject to this section, the old law or the applicable law as to the admissibility of statements applies. So whatever the law is in relation to the admissibility of statements is subject to the provisions of Section 56. Now, Section 56 says certain things have to be done before a statement is admissible. And if they're not, it isn't admissible. And the problem, as I see it, and I sincerely hope that His Lordship is correct, that these obligations don't arise until the police have reasonable and probable grounds to believe that an offense has occurred. If you had an example, His Lordship gave an example, if you had an example of the police arriving at a schoolyard where a window has been broken, and they see a young fellow there who either by his actions or he may have a cut in his hand, they approach him and say, "Did you break that window?" And he says, "Yes, I did." As I see Section 56, there's no way in the world that that can be entered as a statement. If you said to him, "Did you break the window?" and he said, "No, but I broke into that house across the street," then you may get it in then as a spontaneous utterance. So I think what Mr. Justice Ewaschuk was saying is that when the police arrive, they don't go up to the fellow and say, "Did you break that window?" They say, "Did anybody here break the window?" And therefore it may qualify as a spontaneous utterance. If I'm right, and believe me, Mr. Justice Ewaschuk has more chance of being right than I have. But if I'm right, I would think even Allan Borovoy would agree with me that the police who arrive on the scene should be able to ask someone in those circumstances, I mean, did you break the window, or did you, stab the man, or whatever it is? And rather than to get out and start going on with this long speech about, depend how old are you, and they probably can't ask that. He has to go on from there and explain all of these things in language that he can understand, and the guy says no. I mean, to me, it's kind of silly, but then I'm a Crown.
Do you have any comment on that, Bond?
No, I think that's enough. Leo's one experience in juvenile court was on Monday of this week. He decided he'd go there to see what it was like to get a little experience for the panel. And unfortunately, it ended very badly because the fellow he was prosecuting, or the young offender he was prosecuting, decided to escape from the courtroom. Leo says he was last seen running south on Highway 10. Now, I don't know whether he's here today, but if he is, Leo would like him to stay after class. He'd like to hammer a statement out of him.
That's consciousness of guilt.
Okay, we're almost out of time. Let me ask you one more question. What is counsel's duty to the court and the interests of the youth as compared with the youth's wishes? Leo?
Well, if a young person wishes a lawyer, his wishes have to be honored. An example of where his wishes do not necessarily prevail is that Section 8 that we discussed. It's not, if he wishes to replace his counsel, or the judge has material that he feels he has to investigate, it is what is in the best interests of the youth that counsel be replaced. but save and except for that, if the young person wants a lawyer, he gets a lawyer at one stage or another. He either gets it through legal aid, has his parents pay for it. As I indicated to Bob at noon, maybe he's robbed enough Mac's milk stores he can pay for it himself, or the Attorney General has to provide for a counsel. The other situation in which it may not be in his best interest would be where he continually asks for remands or adjournments in order to get counsel. There comes a time in that regard in which his wishes are replaced by the fact that he is going to be forced to proceed without counsel. So in that instance, the situation will come about in which it's not his wishes, but I suppose what's in the best interests of the administration of justice.
Got a comment, Bond?
Yeah, that's subsection 8. I see that differently than Leo. I don't know whether that section is referring to his interest in getting another lawyer, or whether the judge, if he finds that the interests of the youthful offender, the young person, as to what disposition he wants to make of the case, differ from those of his parents, whether then he has to assign or shall ensure that he's represented by a counsel independent of the parents. The section is not very well drafted, and I think it's going to lead to some difficulties. The obvious situation is where the child is going to go. The parents want him to stay at home, or maybe want him to go to training school. The child wants to go somewhere else. And there's counsel that's been retained by the parents standing in court. Now, is the judge required at that point to ensure that he has independent counsel? Where does counsel's position lie? He may be asking the court on behalf of the young person to do something that he knows in the long run may not be in the young person's best interests, but it's something that the young person, his client, wishes to have done. Where does he go at that point, and what does the judge do? And does this section leave it open for counsel to be representing the parents and the judge to be appointing independent counsel to represent the accused? The whole thing is just a mishmash, and I think is a very dangerous subsection, and it's going to have to be tested, and judges like Lucien Beaulieu here are going to have to, I guess, wrestle with it. But I think it's fraught with difficulty. The whole issue of counsel in the young offenders court and juvenile court, of course, is something that's been kicked around for some years, and I'm glad to see Section 11 in, because now it makes the young offenders court a court. It's no longer a social work agency, it's a court. And I think it's a good thing in the long run that at least they've ironed out their difficulties, and they've now recognized that it's a court and you're entitled to have a lawyer there. But that subsection, I think, is going to cause a lot of problems.
Thank you, Bob. I think we'll wrap it up. Lucien.
Well, thank you very much, Bob, Leo, and John. This concludes today's sessions. You've all been very, very attentive, and that bespeaks of obviously the quality of the participants. And on behalf of all of those who participated in the planning committee, I want to thank all of the participants who appeared on the panels, the lectures, volunteer time, individuals who are obviously extremely very busy and made a tremendous contribution in my view. I also want to thank the members of the Planning Committee, Judge Naismith, Barbara Ferns, John Pearson, Bob Holden, Jack Clayton, and Heather Walker, who spent a tremendous amount of time. And I think the record also should show that George Colin Williams invited me to consider something of this nature some 3 years ago, I think it was now, when the threatened, I think at that stage it was still a Young Offenders Act, not the Y Pickle, but was interested in putting on a program of this nature. And I think it's basically also a lot of the credit has to go to his initiative. As I started out this morning by saying that this is a new ball game, as Bob has just said, we're now talking about young offenders being dealt with in a court. I think I want to reiterate the little message that I tried to get across this morning, that not only is it a new ball game, but in terms of the analogy that I used and I like about that expressive character being the fact that it is a court of law and not a social treatment agency anymore, that the important thing in the long run is going to be what Charles Reasons calls, as I said this morning, the instrumental character, and that is going to depend effectively on what you and I do with respect to how we put this into effect. Let me say a sincere thank you on behalf of all of the Planning Committee for your participation and your presence today. Those of you who participated, I don't know if you knew beforehand. You didn't sign any documents, but there is some indication that your contributions will be presented in other parts of the province, and that makes us even doubly grateful to you for the time you have taken out of your busy schedule today. With that, I say one last sincere thank you and good luck to you in your endeavors.